Als.
Ja, ik heb hem nou wel. Ik mag hem ook geven.
Maar laat het zo voor over de ethics zo in.
Wat wil je dat doen?
Hij is al. Als je een video hebt,
Dat je moet kijken.
Hi, Natasha. This is a test just for you. Again, a very brief test. This is to see if the sound is working. Hi, Natasha. When you see this video, you should be able to hear me as well. If you see this video, you should also hear sound. Hi, Natasha. If you see this video popping up, then you should be able to hear me. Hello, Jin. Hopefully you can hear me this time. Please let me know. Hello, everyone. Thank you for checking in. I'm going to be placing you in breakout rooms. So give me 1 minute and then you can discuss some final things before we start in half an hour. Hello, everyone. Thank you for joining this session. We are waiting for the judges who will be arriving momentarily. Oh, mute, links. I believe everyone is in the session. Thank you for joining. I'm going to give the floor now to the president of today's court, Judge Detling Ott.
Good afternoon, everybody. I welcome you to this session of the International Court of Justice. This session will deal with the case submitted to it with an agreement by the parties. And with this, I would like to invite the applicants to start their pleadings.
Thank you, Madam President. Before I proceed on to my submissions, I just wanted to clarify if I am perfectly audible and visible to all of you.
The audio is a little bit unclear, but I can hear you so far.
Yes, I can hear you as well. If you can get a bit closer to the microphone, that would be better.
Absolutely. Is it better, Your Excellencies?
A little bit, not much.
Hello, Mr. President and Your Excellencies. I think the timekeeper's mic is a little bit blurry. My apologies for that.
That is okay. Everything is fine. I can hear you loud and clear.
Thank you.
As far as I'm audible, Your Excellencies, I can proceed with your permission.
Okay, so please proceed.
Madam President, Your Excellencies, a very good morning, afternoon, or evening from wherever you're joining us. This is Agent Shashwat Avasti, along with my co-agent, Ms. Aisha Zaidi, appearing on behalf of the applicant, the Democratic Republic of Togoland. We will be speaking for 14 minutes each and respectfully reserve 2 minutes for rebuttal. Your Excellencies, Letitia's failure to comply with its international obligations has already caused a number of safety-related incidents, and the present case is a manifestation of Letitia's disregard towards the safety of civil aviation in its territory. In that context, I will be dealing with our first two submissions, particularly those relating to Letitia's obligation to establish air navigation services under Article 28 and Annex 11 to the Chicago Convention. And secondly, Letitia's obligation to assist Flight 1984 under Article 25 of the Convention. My co-agent will be dealing with the remaining two submissions. Coming to the first submission, Your Excellencies, we have two main arguments. First, that the standards under the Chicago Convention are binding upon the state of Letitia, and any non-compliance would constitute a breach of the convention. And secondly, Letitia must comply with the terms of the relevant ICAO regional plan and the recommendations issued by the ICAO Council. Article 28 of the Chicago Convention casts an affirmative duty upon contracting states to harmonize their air navigation facilities with the ICAO standards as far as practicable. Since the term practicable is not defined anywhere in the convention, Your Excellencies, its interpretation must align with the object and purpose of the Chicago Convention in accordance to Article 31 of the Vienna Convention on the Law of Treaties. This object and purpose is embodied in Articles 37 and 38 of the Chicago Convention, which seek to achieve the highest practicable degree of uniformity in the facilitation of air navigation services, and accordingly afford the states with the discretion to either comply with the standards or file their deviations under Article 38. On that note, I would like to draw the attention of the bench to paragraph 1 of the record, which makes it clear, Your Excellencies, that Laetitia has not filed any such differences with the ICAO Council, and therefore it must comply with the ICAO standards under Annex 11. This watertight system ensures that liability can be attached to states for non-compliance in case of safety-related incidents, such as the present case, Your Excellencies. This view finds support through the writings of noted air law scholars such as Michael Milday and the former ICAO Secretary General, Asad Kotai. Coming to the breach of these standards, Your Excellencies, we submit that Laetitia has breached the standards in two major ways. The first breach is overall or general in nature. Your Excellency, do you have a question?
Yes, I do have a question. If you are, I was going to interrupt you, but at this stage, then I will place my question. Is your position, do I understand that correctly, that there is no distinction in a breach of an article of the Chicago Convention and a breach of any standards? That the consequences are the same in legal terms?
Thank you for that question, Madam President. Madam President, Article 28 is a broadly worded provision, and the particular standards are defined in Annex 11 to the Convention. The two must be seen as a holistic safety code, and therefore a breach of Annex 11 would automatically constitute a breach of Article 28 if no deviations are filed under Article 38 of the Chicago Convention.
Yes, continue, please. Thank you.
Coming to the first breach, as I was submitting, Your Excellencies, we submit that it is an overall or breach of a general nature, wherein the air navigation services established by Laetitia over its territory do not correspond to the needs of international civil aviation and suffered from repeated failures, causing a number of safety-related incidents in the past. The second breach relates to the present incident, wherein Letterfly was unable to locate and adequately assist Flight 1984, thereby endangering its safety. I will be elaborating on the specific inadequacies in Laetitia's response while dealing with my submissions under the issue relating to Article 25 of the Convention. But before that, Your Excellencies, coming to the binding value of the regional plans and the recommendations issued by the ICAO Council, we submit that a determination as to the binding value of these instruments must be based upon the purpose they seek to achieve. On that note, Your Excellencies, regional plans are the result of extensive deliberations and are based upon a consensus representing what the states in a particular region have deemed practicable in terms of air navigation facilities for the near future.
I do have a question. I would like to interrupt again. Is then your position that if standards are as binding as the provision of the Chicago Convention, what about the licensing requirements for pilots? Are these the same standards?
Your Excellencies, although mentioned under a different annex, the standards relating to licensing of pilots are also binding upon the contracting states, but only the standards, Your Excellencies, and not the recommendatory practices mentioned under the annex.
Thank you.
Your Excellencies, the binding value of regional plans has been recognized by the legal committee of the ICAO in its 31st session, and also by the ICAO European Air Navigation Group, which has described the
Excuse
plans.
me, agent. Excuse me. I have a question. the binding force is recognized by the legal committee of ICAO. This is what you just said. Where is the authority of legal committee to recognize the binding force of this type of action? Thank you.
Your Excellency, I have a two-point answer to your question. First, the context in which this binding value was recognized. The legal committee was dealing with a question relating to the jurisdiction of a coastal state upon an artificial island. And the ICO legal committee explicitly recognized that the jurisdiction would be determined according to the terms of the regional plan that was entered into by that particular contracting state. Secondly, Your Excellencies, why are the legal determinations made by the committee relevant for this court? Under the convention, Your Excellency, the legal committee of the ICO is the most representative body of the agency and is tasked with interpreting the obligations under the convention and questions of general legal importance relating to international civil aviation. And therefore, it is a submission that they must hold a persuasive value before this court. Thank you, Your Excellency. In such a situation, a state must file its objections to the plan, or at least provide a formal justification if it cannot comply with the terms of the regional plan. In the instant case, Your Excellencies, Letitia has unilaterally decommissioned some of the facilities required under the plan without raising any objections in the regional meeting or providing a formal justification as to non-compliance. In such a situation, even if there is a soft nature attached to the terms of the regional plan, they must be binding upon Letitia because it has not filed any objections to such terms. Coming to my last submissions, which relates to the recommendations issued by the ICO Council. Your Excellencies, the safety-related obligations within the framework of the convention take into account the interests of all states and are inherently linked to the safety of passengers. As such, they must be characterized as erga omnes obligations of a state, as per the definition provided by this court in the Barcelona traction case. What this characterization would do, Your Excellencies, is that it would require the states to take all possible measures to implement the safety-related standards. In the instant case, Your Excellencies, Letitia has neither complied with the ICAO standards or the terms of the relevant regional plan. And since the recommendations issued by the Council were aimed at fulfilling this enforcement gap, Letitia must comply with such terms. And assuming for a moment, Your Excellencies, that it was indeed difficult for Letitia to implement these recommendations on account of financial reasons, we submit that Letitia could have sought the financial assistance of the ICAO Council under Article 70 of the Chicago Convention. Not doing so clearly indicates the lack of intention on the part of Letitia to improve its air navigation services. With this, Your Excellencies.
Can I just interrupt for one moment on a question about what is adequate air traffic control? Is it because the radar was down that they breached, or because there was Class G airspace? Because it seems like those two things happen in most jurisdictions. And secondly, are we the right body to decide that?
Your Excellency, answering your first question first, it is our submission that even in a Class G airspace, that is an uncontrolled airspace, basic requirements of air navigation services must be provided to an aircraft if it requests so. And in the instant case, even the basic minimum air navigation services were not provided to Flight 1984. Coming to the second question, Your Excellencies, this forum is the appropriate jurisdiction to decide upon the matter, as the ICAO Council could not reach a decision under Article 84 of the Chicago Convention.
Thank you.
Your Excellencies, it is our submission that state discretion under Article 25 is not absolute in nature and must be based upon risk assessment or reasonability. We rely upon the case of Ingham versus Eastern Airlines, wherein the United States Court of Appeals ruled that the exercise of discretion in providing measures of assistance to an aircraft in distress must be based on reasonability. Coming on to the inadequacies, Your Excellencies, we submit that there were three major inadequacies in Letitia's response. First, there was a lack of contingency arrangements in the event of a radar failure. Your Excellencies, Letitia failed to provide any alternative services despite repeated failures being there in the past, which have led to such emergency maintenance. This is a clear breach of Standard 2.2 of Annex 11. Further, no notification was provided to the Brocolandian authorities with respect to such emergency maintenance, which constitutes a breach under Annex 15 to the Convention. The second inadequacy relates to radio silence and no-fuel assistance. Your Excellencies, despite the information regarding dangerously low levels of fuel, Let Us Fly failed to provide any assistance or take regular updates about the fuel status of Flight 1984. To the contrary, Your Excellencies, there was a 27-minute radio silence between Flight 1984 and Let Us Fly, which is clear from paragraphs 24 and 25 of the record. This is a clear violation of Standard 2.22 of Annex 11. And lastly, Your Excellencies, there was also a failure regarding information of collision avoidance. Your Excellencies, Let Us Fly did not issue any warnings about the collision hazards that Flight 1984 encountered during its approach, causing it to narrowly avoid a hilltop. This constitutes a breach under Standard 4.2 of Annex 11, as information regarding collision avoidance is a basic flight information service which has to be granted in all airspaces. These factors raise a very important question, Your Excellencies, which must be answered by the state of Letitia. If it was any other aircraft, Your Excellencies, I note my time is up. If I could just conclude my submissions. Madam President, you're on mute.
You have 1 more minute to finish, please.
Thank you, Madam President. Coming back to the question which the respondent must answer before the court today, if it was any other aircraft, leaving aside Flight 1984 for a moment, would Let Us Fly be able to assist that aircraft in the particular airspace, considering the state of air navigation facilities in Letitia? In the instant case, Your Excellencies, Flight 1984 was clearly an aircraft in distress as per Standard 5.2 of Annex 11, because it was facing a continuous fuel shortage and was also affected by unlawful interference. We are not submitting anything with regards to the right of Flight 1984 to enter the Letitian airspace. On that note, I would like to conclude my submissions, Your Excellencies.
Thank you very much. I would like to invite my fellow judges whether they have any additional questions for Agent 1.
Not at this time.
I don't have any question.
Thank you very much.
Your Excellencies.
Thank you very much. Then I would like to invite Agent 2 for the applicants to present its arguments.
Madam President, just confirming that I'm audible.
Yes, you are audible, loud and clear.
Good morning, good afternoon, and good evening, Madam President, Your Excellencies. I'm Aisha Zedi, co-agent for the Democratic Republic of Brocoland, and I shall be making 2 substantive submissions. Our third submission pertains to the obligations under Article 3 of the Chicago Convention, and our final submission is concerning the overall responsibility of Letitia for the incident. Before I move to our third submission, it is important to address the court regarding the circumstances prevailing in Brocoland. Your Excellencies, the political situation was volatile and there was mounting tension on authorities to safeguard their national interest. For this reason, the military forces were on high alert and equipped with powers to intervene. Moving to our third submission, we submit that it is in this context that military activities were regulated and obligations under Article 3 were fulfilled to the furthest extent it was possible. Your Excellencies, I shall be addressing two broad concerns. Firstly, that military activities of a state cannot be regulated under the Chicago Convention. And secondly, that Brocolandian authorities maintained due regard during all phases.
Before you start your argument, I have a first question to better understand. Are you saying that any obligation under the Chicago Convention is dependent on the political circumstances in a country?
Indeed not, Your Excellencies. Our submission is that military activities of a particular state are the sovereign function of that state. And as per Article 3A of the Chicago Convention, these state aircrafts, which includes military aircrafts, are excluded from the scope of the convention. It is in this circumstance that political situation of a particular country would regulate the military aircrafts. However, it is not our submission that all particular activities or regulations would be according to political circumstances. Moving further, Your Excellency, this interpretation is also confirmed by the logical construct of the Chicago Convention, which seeks to only address and regulate international civil aviation. And as submitted, the nature of defense and security operations that military aircrafts undertake, it would not be possible to regulate them on an international level. However, Your Excellencies, addressing your concern, we do understand that military and civil aircrafts frequent the same skies, and their interaction is inevitable. And it is in this context that Article 3D of the Chicago Convention seeks to regulate and ensure safety of civil aviation. Under this, Your Excellencies, state aircrafts are regulated only to the extent that states are required to undertake a duty to maintain due regard. And Your Excellencies, it is also important to note that unlike a case of regular hijacking, in this case, a domestic flight was hijacked by the co-pilot herself. In such an extraordinary situation, the annexes as well as relevant...
Yes, excuse me, before you continue, is there a distinction between regular and irregular hijacking?
Your Excellency, the submission that we have before this court is that in cases of hijacking, it is usually the passengers or rogue passengers, if I may add, who undertake or unlawfully interfere in this particular flight. This constitutes an extraordinary situation where the co-pilot herself hijacked an aircraft, and considering little to no assistance was provided by the annex as well as relevant documents which concern unlawful interference, it is important to understand the present context of this case. Your Excellencies, the military had far-reaching intervention powers and had undertaken the responsibility to safeguard Flight 1984. In this context, a preclusion from the normal coordination process was allowed to ensure safety of passengers. And this is clearly provided as one of the standards in the ICAO document 9554, which is a manual concerning safety measures by military activities with regards to civil operations. Your Excellencies, we submit that it is in these peculiar and particular circumstances that military activities of a particular state entailed in a state regulation are regulated, and due regard, which is present in Article 3D, was maintained to the furthest extent it was possible. This is visible from two facts. Firstly, that instead of undertaking hazardous measures that could potentially endanger the passengers on board, the military jets merely monitored the flight from a safe distance. Secondly, the Brocolandian Air Force, which was the ATC taking care of the situation, ensured precautions when it requested Brocontrol, the civil counterpart, to keep them abreast of any developments of the civil aircrafts. And in this regard, Your Excellencies, rapid communication was maintained as provided under Annex 11, Standard 6.2. This can also be seen when the unlawful interference was happening. The information regarding the same was provided to all authorities in Brocoland as well as Latusia at a moment's notice. And secondly, The second, the flight informed about a fuel shortage, as well as their need to land, and interception was conducted by the Air Force. Your Excellencies, in this regard, we also submit that interception was only conducted as a last resort upon intimation that the flight was losing fuel continuously. And even then, attempts were made to land the aircraft at an airbase that was nearly 50 nautical miles away from the aircraft and would have been appropriate considering it was in the territory of Brokoland. In this regard, Your Excellencies, due regard was maintained since attempts were made to directly establish contact with the co-pilot. However, even despite using firstly visual signals, secondly aerial maneuvers, and lastly repeated calls from the Air Force, as are measures prescribed under Annex 2 with regards to interception, all of these attempts by the Air Force were rejected or ignored by the co-pilot, who was hostile and adamant on crossing the border and entering Lututia. Your Excellencies, what is visible is that the co-pilot had no intention of landing anywhere in Brokoland. But what is also visible is that the Brokolandian authorities, from the moment of this unlawful interference till the time the flight entered into Lututia, made all possible attempts to ensure that firstly, the safety of passengers was maintained, and secondly, that the aircraft lands within its territory. And hence, we conclude and submit that Brokolandian authorities complied with the due regard norm present under Article 3D of the Convention. In this regard, they expressly denied authorization, and all possible attempts after that unauthorization was to contain the incident within our boundary. However, what can also not be denied is that once it entered into Lutusian boundary, Lutusian activities or rather inaction further endangered Flight 1984.
Thank you.
Agent, what is the obligation, in your view, of the respondent in the cooperation regarding the event of hijacking?
Your Excellency, in this regard, cooperation should have been maintained by LetUsFly, even considering their military activities, if they do go forward and admit that they did not have the requisite navigational facilities to do this task on their own. However, not only that they did not seek assistance from Brokoland, they also did not employ any further measures with regards to providing assistance to Flight 1984.
No, Agent, I'm asking you, is there any obligation for international cooperation under security conventions such as Tokyo Convention of 1963, Montreal Conventions of 1971, Hague Convention of 1970?
Your Excellency, in this regard, Lututia and Brokoland are not parties to these conventions, and hence the international obligations would not arise under these conventions, and we would have to rely upon the articles of the Chicago Convention, to which both of these states are parties.
Are there any provisions in those conventions that are customary international law?
Your Excellency, with regards to coordination and seeking assistance from a particular state where a domestic aircraft reaches into another aircraft, there exists to be certain provisions under these conventions. However, I would not be aware of whether they have risen to the level of customary international law.
Thank you.
Your Excellencies, we submit that with regards to the fact that although there were no casualties, there is a need on part of Lututia to go forward and ensure guarantees of non-repetition of this accident and ensure cessation and compliance of its international obligations. I shall lastly be addressing the court regarding the responsibility of Lututia and answering the question that Your Excellency raised to my co-agent. Your Excellencies, the concern regarding Annex 1 and the co-pilot's license. We submit that Annex 1 accords a special treatment to pilots with depression under a recommendatory practice, where they are allowed to fly if the medical assessor detects that the same will not interfere with the safe exercise of their license. And this allows states discretion, with countries like New Zealand and Canada allowing pilots to fly. Your Excellencies, to support my case regarding mental health, I would also like to bring to Your Excellencies, if I may be allowed a minute to conclude my submissions.
Yes, please continue. You have 1 minute.
Your Excellencies, I would like to bring to your attention 2 incidents, one concerning the Germanwings flight and the second concerning the Ethiopian Airlines. In the Germanwings incident, the flight crashed into the Alps, and during investigation, it was found that the pilot had suffered from depression and had been issued warnings. In the present case, Your Excellencies, the co-pilot was flying in the mountainous region, and even with little to no assistance from Lettucefly, it was able to land the aircraft safely and was still able to respond to the topographical difficulties. With respect to the second case of Ethiopian Airlines, where the co-pilot had hijacked this airline, the court had not awarded a penalty since it determined the pilot wasn't capable of making competent decisions. However, the respondents in the present case have sentenced the co-pilot to 6 years in prison, indicating that she possessed mental capacity. Since in the present case, the knowledge of treatment for depression was coming out in July 2018, it does not indicate that the pilot is depressed currently or was depressed even in 2018. And considering no warnings of any kind were issued and an investigation is still undergoing, Brocoland had reasonable discretion to not revoke or withdraw such license. These factors, Your Excellencies, along with the fact that the co-pilot is a private actor, indicate that Brocoland fulfilled the objective standard of due diligence it had to provide to prevent the occurrence of the incident, and therefore is not responsible for endangering Flight 1984.
Okay, thank you very much. Any questions from my fellow judges?
No, thank you.
Then
I have a
with
further question.
Yes, please, Judge Huang.
Applicants, you have decided to use the limited judicial resources to handle this case, but in fact, there is no actual damage arising from this incident. Why do you need to go to court for this?
Your Excellencies, we believe that in the light of the principle that is derived from the Chorzo factory case, Vitucia must make reparations in 2 aspects. Firstly, they must discharge the burden on how they would prevent any other similar incident and give guarantees of non-repetition of such an incident as per Article 31 of Articles on State Responsibility. And secondly, in light of Article 48 of Articles on State Responsibility, it must make reparations in the form of cessation and compliance with its international obligations to the world at large, as well as for the particular harm and moral damage it has caused to the international reputation of Brocoland in the form of a public apology. And hence, we believe that we can approach the court for these reparations.
Thank you, co-agent, for the applicant. Now, I would like to invite the respondents to present their case. Agent 1 for the respondent, can you hear us?
Yes, I do.
Excellent. Okay, now we have you. Thank you. Please start.
Madam President, Your Excellencies, may it please the court, my name is Long Yi Ao, and I, along with my co-agent, Ms. Shanwai Chan, represent the respondent, the Federal State of Letitia. I will be addressing prayer A and B with 14 minutes, and my co-agent would then address prayer C and D with 13 minutes. We would reserve 3 minutes for rebuttal. This case concerns the serious incident of Brussels Air Flight 1984, happens on the 3rd of November 2019. In light of this, for prayer A, we respectfully request this court to affirm that, first, the respondent is not in breach of his obligations under Article 28 and Annex 11 of the Chicago Convention. Second, the respondent can't be obliged to comply with the applicable terms of the ICAO Regional Air Navigation Plan, here called the RANP, and the recommendations issued by the ICAO Council, here called the ICAO recommendations. We put forward 4 key submissions. First, the Chicago Convention is applicable in the present case. As contracting states, both the applicant and the respondents are bound by the articles in the convention. Second, unlike standards, recommended practices in annexes do not give rise to any international obligations due to their nature as soft law. Third, the respondent can't be obliged to comply with the terms of RAMP and ICAO recommendations on 3 separate grounds. First, RAMP's formulation was neither embodied in articles or the standards and recommended practices as part of the convention. Similar to the procedures of air navigation services and the regional supplementary procedures, annexes to warrant RAMPs are simply too itemized to warrant adoption as annexes and can only be seen as technical and operational documents separately recommended to a contracting state for implementation. Also, that does not involve a consent by states to be expressly bound by the process of ratification.
Agent,
yes.
I have a question. You mentioned the annex is only a recommendation. Can you expound to me what are the elements of the annexes, whether all of them are recommendation? Thank you.
Thank you, Your Excellencies, for your question. So the legal status that the respondent submits here is that they are of voluntary nature. So in practice, neither the ICAO nor other contracting states had any clear and objective information on the degree of implementation of annexes in the field. It was realized in 1992 ICAO Assembly, as well as in 1995, the conclusion reached by ICAO Secretariat that a large number of states had not notified ICAO of their compliance with or differences to the annexes for some considerable time. In 2005, 109 states provided no notification whatsoever. There has been very low response rate of member states to their conformity with the requirements of the annexes. If we look at the definitions, that illustrates a differential treatments between standards and recommended practices as well, as seen from the words used on notifying ICAO of differences under Article 38. While the respondent submits that standards on its literal definition interpretation are binding, the recommended practices would generally view as soft law with a voluntary acceptance by the states. Thank you.
Yes, but Agent, in this particular case, which recommendation you consider is only voluntarily and therefore do not require any binding effect? And where are those who are actually containing the binding effects? Are there any specific provisions? Thank you.
Thank you, Your Excellencies. So for prayer A and B, we concern about Annex 11. So standards under Annex 11 are binding, while recommended practices in Annex 11 are not binding, for example. May I proceed?
Thank you. Please proceed.
So turning back to the third submission of prayer A, that the respondent can't be obliged to comply with the terms of RAMP and ICAO recommendations. On the second ground, that the use of the words in RAMPs, such as dynamic or flexible plan elements, illustrates its inherent flexibility for subjective determination for its implementation. These elements neither dictate when or where they must be followed, nor do they require to be applied in every state. Third, sharing the same voluntary nature, ICAO recommendations made to replace and upgrade air navigation facilities are merely advised to encourage states to get in line with the RAMP. Latitude is permitted for the development of such details which may be needed to satisfy local conditions. The role here by the ICAO Council is of advisory nature, as shown under Article 69, quotes, "No contracting state shall be guilty of an infraction if it fails to carry out these recommendations. The ICAO recommendations themselves are dependent on the particular circumstances of each contracting state. They were issued in respect of RAMP which is a parallel supplementary guidance. They shall not carry any legal binding force on the respondent. Recognizing that states might have insufficient human or financial resources, or their limitations due to unique geographic or technological characteristics, especially that in the respondent's case, a significant investment is required to fully conform to both RAMP and ICAO recommendations.
I have a question here. You must be aware that airlines are paying for air navigation services, and a country can levy charges. So that would include money for investments. How then should we understand that as a justification not to provide certain equipment, that lack of financial resources are the reason?
Thank you, Madam President, for your question. So as for the financial resources restraint, it is from the facts in this case that the respondent does indeed do not have sufficient financial resources, whether there is any investment or funding. It was in fact that it does not possess any sufficient financial resources for such to comply with RAMP and ICAO recommendations. Thank you.
Yes, please proceed. Thank you.
So moving on, it must also be stressed that the attempt of the respondent in good faith to comply with the RAMP in authorizing the use of GNSS signals should not be brushed aside. Such level of deference can't be owed by the respondent by constructing the relevant piece so narrowly to only to the interest of any particular state, but not with respect to the compelling interest in reasonably serving the basic needs of international aviation as established under articles in the convention and the standards in the annexes. The alleged obligations would be highly prejudicial to the respondent and can't be imposed on it as such. Fourth and last, even if the applicant contends a holistic view on the applicability of the convention and its annexes, the respondent submits there is no violation of both Article 28 and Annex 11 for 3 reasons. First, the airspace sector in where Flight 1984 crossed the border at 9:21 is classified as G under ICAO ATS airspace classification. Under Standard 2.6.1 in Annex 11, quotes, Class G, instrument flight rule and official flight rule flights are permitted and receive flight information services if requested. In a Class G airspace, flight information service is only available upon request. Flight 1984 did not communicate such requests to the respondent. Under Appendix 4 in the same annex, Let Us Fly has no responsibility to control ATC clearance, air traffic control, and there shall not be any specific requirement for the equipment provided in the uncontrolled Class G airspace. Second, due to the improper flight conducted by the co-pilot, that was, flying with a low level of views at a low altitude over an uncontrolled area of topography that blocked navigational signals. The circumstances rendering air navigation services to identify the aircraft or to provide positional data impossible. Lastly, the respondent submits that Let Us Fly has provided appropriate, adequate, and practical air navigation services to the aircraft by maintaining a direct and continuous two-way communication with the aircraft between the time 9:20 to 10:02. The system of which satisfy the obligation to operate a system of communication required under Article 28 and Annex 11. Therefore, there was no breach under such convention. For the foregoing reasons, I respectfully request that this court to find in favor of the respondent. Madam President.
Yes, Mr. Agent. What is then your view about the scope of obligation under Article 28 regarding the provision of air navigation facilities? According to what you just said, does it mean you have no obligation at all? And you mentioned the annex is only voluntarily. Why do you use the appendix of the annex now to support your view?
Thank you, Your Excellencies, for your question. As set out previously, actually, we are saying that we're submitting that recommended practice is not binding on the defendant, on the respondent. That's why we quote, for example, for the air navigation assistance provided, we quote under Standard 2.6.1 or the Appendix 4 in the same annex. Also, we can see that the scope of the Article 28 actually sets out the scope that Article 28 covered was actually complied with by the respondent. Thank you.
Can I just ask to clarify, wasn't this an aircraft in distress, and doesn't that create additional obligations for air navigation services since this was an emergency, or are you saying this is not an emergency?
Thank you, Your Excellencies, for your question. So we do not dispute that this is an aircraft in distress. May I proceed?
And so you're recognizing that there are obligations for air traffic services in that situation?
Yes. Thank you.
Thank you.
So, Madam President, Your Excellencies, if there are no further questions, I will proceed to Prayer B. For Prayer B, we humbly ask this court to affirm that the respondent did not breach his obligations under Article 25 of the Chicago Convention for 3 reasons. First, as contracting states, the respondent is bound by Article 25. Second, obligation under Article 25 only arises when an aircraft in distress is within the state's territory. Therefore, prior to its entry, respecting the applicant state sovereignty, the respondent neither needed to provide any form of assistance nor was obliged to offer air navigation service to the aircraft. Third, upon its entrance, the respondent had provided assistance as far as practicable by, firstly, determining from the insufficient information received from the co-pilot the relative position of the aircraft as required under Standard 3.3 in Annex 11 for the operation of ATC service. Secondly, maintaining a direct, continuous two-way communication with the aircraft. And lastly, providing the necessary air navigation assistance to an aircraft in distress. All requirements under both Article 25 and Annex 11 were complied. The absence of radar services due to emergency maintenance and the fact that Flight 1984 received erratic signals caused by pilot disorientation does not amount to a breach of Article 25. For the following reasons, I respectfully request that this court to find in favor of the respondent. Unless I can be of any further assistance to this honorable court, this concludes my submission. I will now invite my co-agent, Ms. Shen Wai Chan, to address the remaining 2 pairs. Thank you.
Thank you, Agent 1. I would like to invite Agent 2 now to present her pleadings. Agent 2, please.
Yes, Madam President. Madam President, Your Excellencies, may it please the court, my name is Shen Wai Chan, and I'll be submitting prayer C and D on behalf of the respondent, namely that the applicant is not in breach of its obligation under Article 3 of the Chicago Convention, and the applicant is responsible for Flight 1984 landing with critical fuel shortage and breaches of international obligation. For prayer C, we'll put forward the submission that Brockalandian Air Force has failed to coordinate with Brock Control, breaching the duty of paying due regard to safety under Article 3D. Further, the situation concerned did not justify the use of a civil aircraft interception by the Brockalandian Air Force. And even if the circumstances did justify, the interception was not up to standard. The respondent cannot agree with the applicant position that due regard to safety is not applicable on military aircraft and subject to prevailing circumstances. The interpretation of 3D has to take into account that safety and security is of utmost importance and first priority in international aviation, evidenced by the preamble of the Chicago Convention. Here, there is no precise definition on the term due regard under the Chicago Convention. Meanwhile, this concept is also found and widely discussed under maritime law. Given the similarity of the nature of these two areas of law, both related to international transportation and their shared common principles, the respondent respectfully requests this court and suggests this court to refer to such jurisprudence. May I point Your Excellency to the famous South China Sea case, where it is held that the extent of due regards will depend on the nature of the rights, their importance, extent of the anticipated impairment, and the availability of alternative approach. Under such, before exercising the right to deploy military jets, the applicant should have taken into consideration potential hazards that Flight 1984 would bring. In particular, the co-pilot who hijacked Flight 1984 was mentally unstable, which poses imminent danger to both passengers and residents on the ground. In this case, the respondent submits that the applicant has failed to do so in 3 aspects. Firstly, Broccoladian Air Force has interfered the two-way communication between Border Control and Flight 1984. 2 military jet fighters were dispatched without communicating to Border Control in advance, so as to the decision of conducting an interception. This has created confusion between Border Control and Flight 1984 and hindered the two-way communication between them. Secondly, there is lack of sufficient coordination between the military ATS and the civil ATS. Here, the civil and military ATS units are separate entities that are not interconnected, and there were no exchange of electronic data between them. The only coordination was performed over telephone exchange without mentioning the above key issues. As a result,
Agent,
yes.
I have a question here. Isn't it purely a domestic flight? Why there is an international obligation here? Because Chicago presumably only applies to the international civil aviation. Before this airplane enter into your territory, has there anything to do with you, whether they coordinated internally or not? Thank you.
Yes, thank you, Your Excellency, for your question. We do not dispute that before Flight 1984 entered into the territory of the respondent, everything, including the acts of the Broccoladian Air Force, did happen within the territory of the applicant. However, the respondent case is that the action of the applicant comes with a consequences of affecting the international community, which bring us to this court. But for the fact that Broccoladian Air Force has failed in observing its duty, Flight 1984 would not have entered into the airspace of the respondent and results into today's incident. Thank you. Your Excellencies, may I proceed?
So in your view, what kind of further duties they should really fulfill in order to prevent the aircraft from entering into your territory? Thank you.
Thank you, Your Excellency, for your question. Regarding the duty of Broccoladian Air Force in trying to stop Flight 1984 entering into the territory of the respondent, we submit that there should be communication and negotiation between the military units and the co-pilot. And in addition, if the circumstances has justified a use of civil aircraft interception after the military units has attempted to negotiate and communicate with Flight 1984, a civil aircraft interception might be suitable in order to instruct it into landing within the territory of the applicant and not entering into the territory of the respondent. Thank you, Your Excellency.
Please proceed.
Thank you. So going back to the submission, that we believe that the applicant has failed in paying due regard to safety. Our final point is that military was not the appropriate ATS unit to track Flight 1984's movement, as a competent ATS under Standard 3.3 of Annex 11 shall be provided with information on the intended movement and actual progress of such aircraft. However, the absence of direct communication between the military ATS and the co-pilot evidence that it is wrongful for the military controller to take over block control's role. And as pointed out by the Excellency just now, we believe that the circumstances did not justify a use of civil aircraft interception, as under Annex 2, such should be avoided and only taken as a last resort. Here, as there is still room of communication and negotiation, it is not a situation where there are no available resorts. And even if the court is of the view that the circumstances justify an interception, the applicant's attempt was not up to standard, as the military has not made all possible efforts to eliminate the hazards inherent in a civil aircraft interception to meet the requirement under Standard 2.3. Here, the co-pilot was not informed of the action taken by the military jets, and no clear instructions were issued from the intercepting units to the co-pilot. Your Excellencies, if there's no further question, I'll proceed to Prayer D. For Prayer D, we'll put forward the following submission: that under Chapter 2 of the draft article of Responsibility of States for Internationally Wrongful Act, in short, ICWA, respective breaches of international obligation by the Civil Aviation Authority, CAA in short, and Brooklyndian Air Force are attributable to the applicant. Secondly, acts of CAA constitute a breach of international obligation under Article 32 and Annex 1 of the Convention. It is the responding case that ICWA is applicable on the applicant as a piece of codified international customary law, as it has been generally accepted and repeatedly cited by ICJ to determine state responsibility, including the well-known Tehran hostages case in 1980. In particular, regarding to Article 2 of ICWA, it stipulates twofold requirement to establish an internationally wrongful act, which is a state conduct that is attributable to the state and constitute a breach of international obligation. It is the respondent's humble submission that CAA has blatantly violated Article 32 and Annex 1 of the Chicago Convention. Under such, validity of license of a pilot and the granted privilege hinges on the holder's competency determined by a medical assessment. The obligation of the authority can be broadly categorized into two aspects. Firstly, a medical assessment assessing physical and mental health of an individual. And secondly, constant monitoring before issuance or renewal of any licenses. We submitted that applicant has breached the above international obligation in three ways. Firstly, the CAA has failed to revoke the co-pilot certificate of competency when knowing that the co-pilot might fall short of the mental requirement under Chapter 6. Secondly, there is a failure of the CAA to forbid the co-pilot from flying Flight 1984. Aviation authority is granted with the power and obligation to ensure pilot certificates were issued based on the appropriate standards. Here, the CAA With the information in mind that the co-pilot's condition may jeopardize the safety of flight, ought to have refined the co-pilot from exercising her privilege under the license and to make flight suspension at its CFEs. Thirdly, there is undue delay of the CAA to conduct investigation on the co-pilot's mental and medical condition. The information that the co-pilot was treated for depression was passed to the medical service back in July 2018. Medical investigation has lasted for over a year, and the co-pilot ought to have been discharged earlier. Regarding the second requirement under Article 2, the acts of the two entities mentioned are attributable to the applicant as they are government agencies performing executive functions and exercising public power. Alternatively, as exercising elements of governmental authority, which will give attribution under Article 5. We, on behalf of the respondent, respectfully request a declaration from this court to the applicant to remedy the non-material injury suffered and a formal apology from the applicant. If I can be of no further assistance to this court, this concludes the respondent's submission. Thank you.
Thank you very much, Agent 2. I do have a question regarding the observance of and the issuing of the license for the pilot. On what legal grounds should this court really consider the obligation not to license a pilot with depression?
Thank you, Madam President, for your question. In fact, under Article 32A of the Chicago Convention, as I quote, the pilot of every aircraft and other members of the operating crew shall be provided with certificates of competencies and license issued or rendered valid by the states. Here, it is the respondent's submission that this court has the jurisdiction and the power to assess if states have been fully complying with this article when issuing licenses and assessing pilots' competency when making their regulation. In particular, I would like to point Madam President to Annex 1, which stated that under Standard 6.3.2.1, an applicant for a pilot license shall not suffer from any disease or disability which could render him likely to be suddenly unable to safely operate an aircraft. And under Standard 6.3.2.2, an applicant shall have no established medical history or diagnosis of any mental or psychological development disorders. These two standards provided and support the respondent case that the authority here has an international obligation to discharge and to revoke the pilot's certificate of competency when it falls short of the mental requirement.
Thank you. Thank you for your answer. I would like to invite, in the interest of time, my fellow judges for further questions to Agent 2.
I have no further question.
No further questions, thanks.
Thank you.
Thank you very much. Now, I would like to invite the applicant for the rebuttal.
Thank you, Madam President. Once again, I would like to confirm that I'm audible to all of you.
Yes.
Madam President, if you could confirm that.
I can hear you, but very barely. Can you please, and I don't see your picture. So Judge Whittaker, can you please respond to the agent of the applicant? Can you
Madam
see
President,
him?
am I audible now?
Yes, we can see him. Your picture is blacked out, Madam President.
Judge Wang, am I audible to you?
I can hear and see him, but it's not clear enough.
All right, Your Excellency. If you could just allow me 5 seconds to fix my mic. Is it any better, Your Excellencies? Is it any better now?
Yes, it's a
Well,
bit
we can
better.
hear you. Yeah. Okay.
Thank you, Your Excellencies. Your Excellencies, I have point-wise rebuttals to the submissions made by my worthy opposing counsels. Your Excellencies, first, they have relied upon state practice and the wordings of Article 69 to disregard the recommendations issued by the ICO Council. However, they have failed to justify before this court as to how then would the enforcement gap that exists with regard to the air navigation services of Laetitia would be fulfilled because, Your Excellencies, they have neither complied with the ICO standards nor the terms of the regional plan, and now they want to disregard the ICO recommendations as well. If they indeed suffer from financial difficulties, as submitted earlier, they always have the option of approaching the ICAO Council and other states under Article 70 of the Chicago Convention. Moving forward, they have relied upon the argument that the concerned territory was an uncontrolled or Class G airspace, and therefore there was no obligation to provide air navigation services. However, Your Excellencies, paragraph 21 of the record makes it clear that the aircraft, that is Flight 194, had clearly requested for the measures of assistance from the Laetitia ATC, and therefore, under Standard 2.6, it was bound to provide adequate navigation services. The services were not adequate, which is very clear from the emergency maintenance of radar, and no alternative services in place, despite, Your Excellencies, there being a number of incidents in the past of similar nature. They've also not justified before the court as to how the information regarding collision hazards was not to be provided, which is a basic flight information service to be provided in all regions. With regards to the due regard obligation, we submit that the interception was indeed taken as a last resort because the military had issued clear orders that there shall only be monitoring, and only upon the intimation of fuel shortage did the military intercept the aircraft, and that too taking full precaution and issuing relevant signals, Your Excellencies. And lastly, they have failed to justify before the court as to how under Annex 11, which majorly lists down recommendatory practices regarding aircraft and pilot licensing, that how can a pilot, which is not even conclusively disabled in terms of mental disabilities, and the investigation is still ongoing for a 2-year incident, should be held unfit for a civil aircraft. Thank you, Your Excellencies.
Thank you very much, applicant. Then I would like to invite the respondents for the Zurich.
Sorry, Mr. President, if you do not mind, I have a question for the
of course. Yes, of course. Go ahead.
Agent for the applicant. I would like to hear your rebuttal about the statement by your adversary about the due regard argument, that you military did not pay due regards to the civil aviation.
Indeed, Your Excellency.
What is your rebuttal on that?
I have a 2-point answer to your question, Your Excellencies. Firstly, with regards to the submission that the military ATC was not the appropriate authority in the instant case. Your Excellencies, there was a clear occurrence of an unlawful interference in this situation, and the military was already on high alert due to the political circumstances. And that is why we believe that the military ATC was the appropriate authority. Coming to the coordination element, Your Excellencies, we submit that as soon as the information regarding unlawful interference was received by the civil ATC, it was relayed to the military ATC, which took all possible measures to control the situation, which is clear from the safe monitoring of the situation, and then taking interception as a last resort. This ensures that there was an effective communication between the two military controllers, Your Excellency.
Okay, thank you.
Thank you, Your Excellency.
Are there any further questions from Judge Whittaker?
Well, I guess I have to ask maybe an obvious question. It seems to me, as listening to these arguments, that one could argue the proximate cause of this event was the co-pilot taking control of the aircraft. And it seems like such a dominant cause that some of these other causes seem minor in comparison. And notwithstanding the suggestion of your co-counsel, the last 3 hijacking events I can think of, German wings, Ethiopian, Malaysian, all involved cabin crew incidents. So I guess my question is, isn't that the proximate cause of this incident?
Your Excellencies, we believe that the fact that the co-pilot had hijacked the aircraft for political and personal reasons is a significant cause, and that is one of the significant reasons why Brocolandian Air Force and the Brocolandian authorities could not control the situation within their airspace. As has been submitted by my co-agent, Your Excellency, the co-pilot had no intention to land in Brocoland, which is clear from paragraph 17 of the record, that despite the authorization and interdiction to proceed, the co-pilot was adamant to enter the Laotian airspace, and that is why we believe that is a significant cause.
Thank you.
Thank you. Also, any further questions? If this is not the case, now I would like to invite respondents with the rebuttal.
Madam President, Your Excellencies, the applicant's submission are flawed for the following reason. Firstly, the applicant sought to rely on the European Air Navigation Planning Group to assert that RAMP is an authoritative and internationally agreed document. This is incorrect. The high level of compliance found in EU is because of the single European sky policies, which seeks to establish a uniform network within the region. The understanding of European countries on RAMP ought to be distinguished from any other states and does not represent the international aviation community as a whole. Secondly, our learned friend's submission on the extent of adequate assistance was based on an ICAO manual, which imposed no binding force on contracting states whatsoever. It is merely a piece of advice issued by the Council that should not be used to interpret the level of assistance required. Similarly, as pointed out by the Excellencies, there is doubt as to applicant's position to cite the legal committee in supporting the binding nature of RAMP. Legal committee is not the ICAO Council. It does not have lawmaking power. Thirdly, our learned friend erred in applying a double standard in their submission. The applicant assert breaches on the respondent in fulfilling the as far as practicable standard without considering the financial difficulties of the respondent. Yet, they later submit that due regard is subject to the actual domestic and political circumstances. This inconsistency and standard of review is unfair, arbitrary, and prejudicial. Regarding prayer D, our learned friends submit that the action of the respondent has led to fuel shortage. But as I have just submitted, but for the applicant's failure to instruct Flight 1984 for landing, it would not have entered into a prolonged holding procedure. Therefore, the applicant is not in a position to blame the respondent. Last but not least, as our learned friend submitted that applicant is not responsible for the incident, relying on defense of distress under Article 24 of the ICAO, it stipulated that defense of distress would not apply, as I quote, when the act in question is likely create comparable or greater peril. There is a foreseeable risk that the unanticipated action of the military unit might have frightened it and triggered the mental unstable co-pilot to resort in radical movement, ending up like the disastrous situation in German wings back in 2015. This seems to suggest that the act is likely to create greater peril when the co-pilot has indicated that she would not do harm to passengers if her instructions are obeyed. This concludes the respondent rebuttals. Thank you.
Thank you very much, Judge Whittaker. Judge Wong, do you have any further questions for the respondent?
I just
No, I have no further question.
Just one clarification. It seems we're being asked to pass judgment on how effectively Broccoland is executing its mental health review of its pilot certificates, and that's an appropriate area for us to inquire into, but that it's not an appropriate area to inquire into whether the ATC system in Latouche is up to international standards. Can you explain why it's appropriate for us to make that one inquiry but not the other?
Thank you, Your Excellency, for a question. May I ask for a clarification? Is that Your Excellency question that why there is a distinguish of this court hearing the respondent's submission that obligation under Article 32 and Annex 1 should be ruled by this court, but then the assistant and also navigation provided by Letitia is not Letitia is not liable for such?
Exactly.
Yes, thank you, Your Excellency, for a question. We made such differences between these two liability because as submitted by my co-agent, the respondent asserted that there is simply no breach of Article 28 and Article 25, even if the standards or even the recommendations or IALMC are applicable on the respondent, as we have already satisfied the standard as far as practicable using the limited resources that the respondent had. Thank you, Your Excellency.
Thank you.
Thank you, Agent. And with this, I would like to conclude this session. The court will now deliberate the case and we will come back with our findings and our decision. Thank you very much, and I close this session.
Ja, ik dacht eerst even gelijk of eerst die slide nog?
Die slide.
My name is
Welcome to Leiden University, an international campus which is home to the most critical thinkers in the world. Ranked 1 in air and space law, we pride ourselves with a diverse, inclusive, and personal approach to education. Our students have changed the lives of millions, and our staff have advanced the human species. But what is it that makes us truly special?
Hello everyone, my name is Ayomide Adefe Jidiomole and I am Nigerian, and I decided to further my studies in aviation law. So I woke up one day and I told my mom, no, I am going to be a lawyer, and it's been a very good experience because I get to do what I love, and I had two main options in front of me, McGill or Leiden University, and it was a no-brainer. I'm sorry, McGill, but come on guys, I'm in the Air and Space Law Institute.
My name is Eugene Duplessis. I'm from Namibia in Africa. I joined the National Airline Air Namibia in 1997, and I felt I needed to go further to broaden my knowledge. And I didn't want to leave aviation, but I wanted to pursue the law as well. And so the blended learning option was the perfect choice for me, where I could continue working as per normal and where I could pursue my studies at the same time.
My name is Tanja Masson-Zwaan and I'm an assistant professor, and I teach space law related content of the Advanced Masters in Air and Space Law here in Leiden. I usually tell that I'm myself an alumna of this university because that is of course something that we take pride in, and it's why you still feel at home after all those years. I am of course a spider in the web and connected to many organizations, which also then is useful for the students to know because they need to find internships and contacts for jobs. And so we invite the students to let us know whenever we can help them.
So the Advanced Masters in Air and Space Law is a very intensive program. We try to combine this theoretical knowledge with practical experience, for instance, by doing moot courts, case studies, or excursions to European institutions or international organizations, or for instance, Dutch stakeholders in the air and space industry.
My name is Pablo Mendes de Leon. I teach air and space law, especially air law, since 1985 at this university. Air law is a very dynamic field of law, and many things are happening there. There are many applications, and there are always things where you have to apply the law to the events which occur. China now with the coronavirus, flights are cancelled. What are the rights of the passengers? What do airlines have to pay? Boeing Max accident last year. Lion Air, Ethiopian Air, what happens there? Huge aviation law related questions. All of that involves the application of air law. So you're always busy in finding solutions for current problems.
I came for air law because air law is what sells right now in the Nigerian market. But we started space law like a week ago, and I am in love.
The most attractive thing about space law is that nothing is written in stone, and that there is always something new that the scientists and the engineers come up with, and then that will definitely raise legal questions, and we have to look at those. So we've always decided to keep them together, because even if you are more interested in air law and you discover space law, you can at some point perhaps introduce in your law firm that it might be interesting to look also at satellite operators as a potential client. And the other way around as well.
It really has opened the life. You know, in space law, you'll say you'll reach for the moon so that you at least land amongst the stars. But that's what I feel like happened in air law here.
It's really helpful. You get to see professors, you know what they're thinking, and then it combines with self-learning, right? Assignments, papers, to get into the details of what you learn in the face-to-face meetings. in Leiden here, the professor is up to date with the recent information.
And that's the advantage we have here, is that they are specialists in their field. So we have a wide variety of topics to cover in both air and space law, and we have the privilege of hearing from it firsthand in practice from the best of the best.
I feel like with every assignment that we make, I get this feeling that this is the right place for me to be, because every time it's something new, I feel like I'm constantly learning something new. So I would say that's the biggest advantage of the program, and at the same time, it's the most challenging.
Just love at first sight, and of course the city is beautiful. I really love being here, and I came here each and every year since then. So basically, it's an amazing place not only to study but also to live and work, and really enjoy every time that I'm here. Whenever I'm invited, I come.
Since we are such a small program with about 35 students every year, it's very close-knit community. We organize a lot of social events like outings to a museum or a movie night, or our famous international dinner that we will have, where students prepare a dish from their country and we all taste each other's dishes and have a fun night, or we do a barbecue.
I would reiterate the fact that my class is a big family. Everyone loves each other for the diverse strengths and weaknesses they bring, and then how we mold ourselves up together. And regardless of whether you're a blended learner, or you're a full-time student or a part-time student, there's always space for you in the Institute of Air and Space Law.
I love my country, don't get me wrong, but I do feel like here you are a person and your family, and you're not just a number.
It's a family. Many people speak of it indeed as a family, where we continue to see each other in a very different atmosphere, and in the moot court atmosphere, but there's also atmosphere of social events where you can catch up with each other. Those are people with whom we are very close with, from a professional, but also I must say from a personal point of view.
Yeah, the good thing about the students here in Leiden is that they come from around the globe. So we have they have their cultural background, they have their different expertises as well. So they bring to the table quite a rich environment that leads to interesting debates at the classrooms. So it's really a thrill to come here to present those lectures, because every time that I'm here, I learn something from the students, and of course that affects my line of research, and also the production, the technical production that I have as an academic. I believe as a professor, our intention is always to assist the students to realize their full potential. So what we try to do as much as possible is to help the students to achieve their professional goals, as well as to realize their personal dreams. That's what drives us as a professors, as teachers, and I believe that's something that's always conducted with a lot of care here at Leiden University. We want to help you to achieve your goals, your dreams. We are here to help you do that. We're here for you.
Can we do that? No, we can't do that.
Natasha. 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 Nitin.
Yes, Stefan.
Natasha, I tried to join Neil, but I'm supposed to go to the classroom.
He's saying like,
Here.
oh, wacht.
I
Oh, yeah, but he's like,
Natasha.
I have to say something.
Hello, Jaifang. I will put you in the breakout room now.
Okay.
No. Yes, Jaifang.
Yes, I'm
Natas, kun jij je screen stoppen met sharen? Welcome back, everyone. Let's give everyone a couple of seconds to connect to audio and also wait for the judges to return, and then they will give their final verdict about who will be the winner of this year's Heirloom Moot Court. Welcome to the judges as well. I think Jay Fang has his screen off. Let's give him 1 or 2 more minutes, and otherwise we continue with the announcement by the president of the court.
Are all the judges with us?
I'm here.
Thank you. Let's wait a brief moment to see whether the third judge is also joining.
Yes, I think Jay Fanning is here as well.
Thank you very much. Welcome back, everybody. The next few minutes will not be as in a normal court session, obviously, because I would like to say or make some remarks which belong to this event, but not to a normal court session. And before I would like to announce the winners, I first of all would like to say thank you to very many people who have made this moot court possible. Of course, my fellow colleague judges here on this panel, but also judging all the other panels, they have done a fabulous job, and I would like to thank them for doing this. It's like everybody, this is something they do on top of their everyday obligations, and more time on Zoom, but this time it was really worth it. And of course, there are others that without them, this event would not have been possible. One says it takes a village to raise a child, and it takes a fantastic team to make a virtual courtroom possible. I am coming from a country where it's not that easy to always convince public entities to sponsor events for aviation. And I'm particularly impressed if I see that among the sponsors also, there is the Dutch government. There is such a strong Dutch background here, from the Ministry of course, Leiden University to KLM, and I think they all also deserve a lot of recognition of supporting this event. And then, of course, I would also like to thank the author of this case. It was a challenge to tackle it also for the judges. It was a very intriguing mixture of live events, and some corners were maybe not out of reality, but also could happen well. So it was a very, very brilliant combination of real life events and possible events. And then, of course, this event has a father, and maybe he's also almost a godfather, and that is Pablo. Pablo, I know you have taken a step back, but without you, this moot court would not be what it is, and it continues to draw on your energy, your enthusiasm, and to provide all the network and input. Thank you for that. This is not just a given. But then, of course, there are others who have made an incredible contribution. It's Nitin and the team with the timekeepers, a very important issue because the timekeepers provide a level playing field for everybody. And we know, we have discussed what level playing field means, but here it's really very important. And as I have seen in one session, you were also the troubleshooters and you did exceptionally well. But then, of course, there are three persons who deserve an extra mentioning. And that's Niall, Jin, and Natasha. Niall, you can see here, and I don't know whether Jin and Natasha are also somewhere to be seen. I don't see you on my screen, but I must say thank you for all your strength, all your energy you have put into this event in many weeks of preparation. I don't even want to know how many times you have gone home and that you have thought this is not going to work. But nevertheless, you kept it up, and here we are. And you have managed to connect the world with technology, not with aircraft, because normally one says aircraft can connect the world. And some final remarks before I announce the winner. Air law and aviation is in a very difficult situation now. And for me, having spent almost all my professional career in aviation, it's fantastic to see so many young people who, despite the difficulties we see now around us, that they are engaged in air law. And I just can plead, continue your enthusiasm. It's worth it. It's a great challenge to work in aviation. It's not easy, and you have seen there is a feature to air law which I personally always appreciate. Every case you would like to see, where is the precedent? And there is no precedent or very little precedence. So every time you have a new case, you have a blank sheet of paper in front of you, and you have to start thinking how a solution could look like. Now, I think what that teaches us, in one sense, all of you are winners of these competitions, because you all have managed to tackle this case. You all have managed to dig deep into the difficulties and the challenges of international air law. And I'm sure if you compare where you were when you started to work on this case and where you are now, that teaches you and shows you, you have learned a lot. And in this sense, as I said, we are, or you are, all winners of the competition. And then today we had the finals, and of course, we have to make a choice. And I must say it was a very difficult choice, again, because the level of the finals is really, really high. And we needed some time among us, so you had to wait for the announcement to see who would be awarded the winner. And so I will not take too long to disclose who it is. When we made the decision, we came also to recognize that it makes a difference between the two agents, how they present the case. And with that comparison, at the end of the day, we made the decision, and the winner of the 12th moot court in air law, the Leiden moot court, is team number 26 from Dr. Ram Manohar Lohia, National Law University of Lucknow in India. Congratulations to your team. And as I said, I would like to especially mention the co-agent of this team. You made a difference. Your pleading was superb, and your presentation, and that at the end of the day made the difference that the Indian colleagues have won this competition. But at the same time, also congratulations to the team number 75 of the Chinese University of Hong Kong. Also, you were very strong. You did an excellent job. You presented well, and your forceful rebuttal also impressed us. So you can feel very proud of yourself being the runner-up in this moot court decision proceeding with this decision we have taken. Again, thank you to all, and enjoy the evening. And I know it's not over yet, so Niall, you will now continue, and I pass the floor to you.
Thank you, Regula, and of course also thank you to Michael Whitaker and Jay-Feng Wang for judging these finals, and congratulations to both teams, because as Regula rightly said, you are both winners. Team 26 beats it by the slightest, I would say. You've done an amazing job today. I understand that I'm actually now standing between the end of this moot court and probably start of a nice evening for many of you, so I will try to keep it short. But of course, there are more winners to this moot court. So I will quickly share my screen to announce some of the other awards. Let me see if this is working. So I hope this is now we're all displaying correctly. So of course, the winners for this year, if you hadn't heard it already, there are Team 26 from the Dr. Ram Manohar Lohia National Law University of Lucknow of India. Congratulations again. And the runners-up, Team 75 for the Chinese University of Hong Kong. Next, one of the other awards that we always give is that for the best memorial applicant. And that is going to team number 23 of the National University of Singapore. Congratulations, you did a really good job, and that's, I'm not saying without any reason, because you also won the Best Memorial Respondent Award. So a double congratulations to you. You were very, very strong in your written submission. So congratulations again. The best oral argument, that is of course the other side of the competition. For the applicants, this is going to team number 4, the National Law of the National Law University, also of Jodhpur in India, strong region, I would say. Congratulations to the team. You did really well in your oral arguments. On the other side, for the respondent, the best oral argument, that is going to team number 26. Again, you have won also double prize today. Congratulations once more. Then the last award already, I'm going at this through this very quick. Usually, of course, we would invite you all to the stage and give you your certificate. We will be sending these later on, so you will still get your prize and your proof that you've won these awards. So rest assured there. Last but definitely not least, we have an award for Best Oralist. And we understand that it was especially challenging this year because you are delivering your speech through a webcam, which is very different from you, of course. But I would like to congratulate Ananya Awasti. I hope I'm pronouncing it right. Again, from team number 4 of the National Law University in Jodhpur, India. You received the highest scores for your oral pleadings yesterday and the day before. So congratulations to you. But as I said, and also as Judge Egla Detling-Ott had said, all teams are winners. And I would like to thank all the teams that have participated in this edition. We are thankful for the trust that you have given us in organizing a competition in a year which has many uncertainties, but we're happy that all of you have been persistent and that you participated over the past 2 days. Thank you to you all. And then I would like to give special thanks to the author of the case. I think David already stressed the important role this person has, and especially this year, I've understand that the case was found by many of the judges and hopefully also the students an interesting case, challenging and difficult. So special thanks to Dr. Francis Schubert, who has taken a lot of time to write this case and to also answer all the questions from the teams that has risen from this case. So special thanks to Francis for all the work that you've done this year. And I would also like to give special thanks to the room administrators or the timekeepers from this year, which were students from the Army Institute of Law in Chandigarh, India, who have taken time, who have volunteered to be timekeepers for this year's competition. And without them, we couldn't have pulled it off. So special thanks to you as well. I hope you're watching and that you've enjoyed working with us over the past 2 days. Thank you again. And last but not least, I would like, of course, to thank the organizing partners. Nitin, you are here on this call. I would like to give the floor to you now for a short speech. So let me.
Thank you, Neil. And I'm not going to take too much time. I know everyone's been logged in for a very long time, but I can't believe that it's going to be almost 12 years since the first competition was held in New Delhi. And I'm not sure whether some of the participants are aware, but the finals today were extremely special. And Madam President, the reason for that is the bench, the constitution of the bench is virtually the same as the first finals that were ever held in New Delhi. We had Dr. Huang as well as Judge Whitaker, who were part of the very, very first moot court final, judging panel for the finals ever. So it's a big deal for everyone. It's really outstanding how this competition has grown from just an idea to this beautiful being. It perfectly fits all of our aims, whether it's Leiden University, the International Institute of Air and Space Law, or the Serene Memorial Legal Aid Foundation. Our whole aim is to give these students who have given so much, just to give them a little bit of recognition, a little bit of experience, and a little bit of pleasure of pleading before the best of the best. The judges that we have are absolutely amazing. It's really, small sparks like this that can, lead to fire. In India, at least, we see, a lot of the students come back to us and, want to join this field. They're joining airlines, they're joining leasing companies. It's really fantastic. I've seen that change in the last decade. In the same breath, I would urge all the students, if you have any questions, any queries, please do reach out to all of us. I'm sure all the judges and all the organizers would be extremely happy to answer any questions that you have, guide you, in how you should proceed further. You're a part of the family now. On behalf of the President and the Secretary General of the Serene Memorial Legal Aid Foundation, I would like to thank everyone from the Leiden Bureau. I would like to thank everyone from the Serene Foundation Bureau, especially Vinamra, Ritesh, and Dhaval, who spent hours training the timekeepers, and of course the timekeepers themselves, who were just so absolutely incredible. And of course, Neil, Natasha, and Jin, thank you very much. We've reached new heights. We're a family now. And thank you so much. Yeah, I'm very proud to be associated with this event.
Thank you, Nitin, for those kind words and for your support, and also that of Vinamba, who's been a great help, especially the last couple of weeks. I really almost cannot believe that this is really going to be the end already. After months of preparation, the last couple of days have gone by so fast, it's unimaginable. And when we had to cancel the oral rounds last year, we were determined to make up for that with the real-life physical moot court this year. And unfortunately, after having to postpone the decision twice, it became clear that students and judges traveling across the world to the same destination also wasn't in the cards from this year. And from that moment on, the organization of this year's moot has really been a roller coaster. We've speeded up the launch of our new website, which has proven its worth 2 times over already. And we also had to work out how to conduct simultaneous court sessions online with time zones ranging from the US to Europe and China and the Far East. It was a very difficult puzzle, but I'm very happy that we've made the decision to accommodate all teams that would have qualified in the normal circumstances for the semifinals. And with 16 teams and an equal number of court sessions and the highest number of judges coming together over the past few days, this really is the perfect example of what the moot courts for us is all about. And it's bringing together students and professionals who share the same interest in air law. I'm also glad that we've put in the extra effort to have a sort of a social program this year to facilitate interaction. It has been really great to see some faces and to speak with people again after more than a year already, or to talk with some of the students with whom we've had only email exchanges so far. Of course, I didn't do all of this by myself. They've already been mentioned a couple of times, but Natasha and Jin really do deserve to share the spotlight with me. Thank you both. I couldn't have wished for a better team. This year's online moot has truly been unique, one of a kind. And while successful, I really do hope that it will remain one of a kind and that next year we can finally meet in person again. I cannot announce the venue for next year yet. But if you sign up for our updates on our new website, you will definitely be the first to know. And with that, really comes an end to this 12th edition of the Leiden International Air Moot Court Competition. For those of you who are now in the spatial chat, feel free to stick around a bit longer. I will be joining you shortly. And to all the other viewers, thank you for watching. I hope to see you at next year's competition or at one of the many other events of the International Institute of Air and Space Law here at Leiden University. Thank you everyone again, and I wish you all a great weekend. Thank you.
Thank you.
Al.
Bye.
Thanks, everyone.
Bye.
Thank you so much.